I'll call the first case on this morning's docket, case number 114271, Christopher Nauheim, the City of Topeka. Council may proceed.
May it please the court, John Hamilton appearing on behalf of the appellants and plaintiffs, Hal Richardson and Charles Nauheim, and I would like to reserve 5 minutes of my time for our rebuttal, Your Honor.
5 minutes is granted.
Thank you. This case involves an interpretation of KSA 26518. Both Nauheim and Richardson were long-term tenants of the seller of properties to the City of Topeka for a public drainage project. Both were holdover tenants as their leases had long ago expired. The trial court granted summary judgment against the plaintiffs, and as a matter of law, the Court of Appeals reversed and found that we were entitled to a trial to determine whether the city would have most likely have condemned the property and put the burden of proof on the property owner. KSA 26518 was adopted to grant all displaced persons resulting from a public project when federal funds are not involved, the same as when federal funds are involved and a person is displaced, whether they are a tenant or a property owner. The Uniform Assistance and Real Property Acquisition Policies Act, commonly referred to as the URA, or the Uniform Act, was enacted in 1970 with the express purpose, and I quote, of ensuring that persons displaced as a direct result of federal or federally funded projects are treated fairly, consistently, and equitably, so that such displaced persons will not suffer disproportionate injuries as a result of projects designed for the benefit of the public as a whole. KSA 2618 was enacted by House Bill 2032. It was enacted in 2003. And the summary of legislation reads, House Bill 2032 amends statutes dealing with eminent domain and relocation assistance to require such assistance to be paid by the state, its agencies, and political subdivisions, even when federal monies are not used for the project.
Counsel, is it your view that the statute is ambiguous? I mean, I don't understand why we care about what's in the legislative record, because our case law is pretty clear that the first thing we look at is the statutory language.
Yes.
So when you look at the statutory language, are you saying that it's ambiguous?
No, Your Honor. I'm not saying it's ambiguous. I'm saying that in advance of condemnation means whether there's condemnation or not condemnation. I think this summary of legislation, although I know it's not part of the legislation, is pretty indicative of what the committee felt that the legislation would accomplish.
So your position is any time a condemning authority acquires land, it owes relocation benefits, period.
That is correct, Your Honor.
And why wouldn't the legislature just have said that?
Well,
rather than creating all this language, which when I look at it, seems to set up two distinct approaches. One would be something that's in advance of a condemnation action, and then the other is through a I think we all know what through a condemnation action is, because the statutes tell us when that trigger gets pulled, and there's a whole process for that. But there's this other criteria, it seems to me, and that's got to mean, those words have to mean something, it seems to me, other than what you want it to mean, which is that any public use project is going to owe relocation benefits. That's what you want.
It is. And that's what I think it means.
How do you get there with this language?
Well, I think it's saying, they could have said without condemnation would have been the same thing. In advance of condemnation, I mean, I don't know why, I don't think the statute was ever intended to put a burden on the landowner to prove that the city, what was in the minds of the city, what they might have done. And in this case, there's ample evidence by virtue of an affidavit from the seller of the property and some emails from the city to the effect, we hope we don't have to condemn.
Sure, but that's after you get into the weeds as to what you
Yes.
can prove or can't prove. We're still looking at the language.
Okay.
Is it your position that a condemning authority would never, ever acquire land except when it was willing to use condemnation to get it?
If it's for a public project, I would say that's correct.
Why can't a condemning authority simply acquire property through negotiation for some future potential use that it wouldn't be willing to use its authority to condemn to get at that particular moment? Why is that a factual impossibility?
It's not a factual impossibility, Your Honor.
So there would be circumstances when a condemning authority might acquire property through negotiation that it would be unwilling to, at that moment, use condemnation authority to go get.
That's possible.
Then isn't that what this statute permits?
No.
Or allows for?
Not in my opinion, Your Honor.
Yeah.
Let me say it this way. I don't think there's I know this is true. There is not a case in the Supreme Court of Kansas where a condemning authority abandoned a project because the landowner wouldn't kick out a couple tenants. There's not such a case.
Well, Counselor, it seems to me that every negotiation entered into by an entity that has condemnation powers has that cloud over the negotiations. Whether they, in their own heart, intend to use it or not, that's part of the negotiation. If you're a landowner, you know that the person negotiating with you can condemn it if they want to. That kind of clouds the negotiation, doesn't it?
That's true.
In this particular case, can I ask you a couple of factual questions?
Sure.
We're talking about tenants that were on, would you say month-to-month, at-will, holdover status?
Yes, sir. They're long-term tenants, but the leases are long expired.
And the landlord terminated that tenancy prior to conveying the property to the city, correct?
Right.
And was that termination alleged to have been wrongful in any manner?
I'm sorry, I didn't hear the last part.
Was that termination alleged to have been wrongful in any manner as between the landlord and the tenant?
No.
And so explain to me why, if a landlord has the authority to terminate a tenancy, that landlord cannot do so before entering into a negotiation with the city to sell that property.
The landlord could, Your Honor.
Okay.
Let me throw out two hypotheticals. One is the city of Topeka sends a letter to a landowner and says, we want to acquire your property by negotiation, which is pretty normal. However, if we aren't able to do that, we're going to condemn it. Then they settle a case, and then the landowner, any tenants, including the landowner, would get relocation benefits because they'd put that in the letter under the holding of the Court of Appeals. And assume another hypothetical, they leave off the last sentence. They don't say, if we can't acquire it by eminent domain, by negotiation, we'll condemn it. They leave that off. Landowner settles under this without having some ungodly burden to prove that they would have condemned it anyway. Tenant doesn't get relocation benefits. It's just not what this legislation was intended to do. The Federal Act provides in every case, any displaced person, that's all you have to prove. You're a displaced person, you get benefits. This act was intended to accomplish the same thing. And it may have that one word in there, I think, simply means without going through condemnation. In advance of that, if we settle, we still have to pay the benefits.
So if the condemnation authority is, the city has it in their head that, gee, that is something that we could do, but they don't communicate that to a landowner or anybody else, in your view, that means relocation benefits should be paid.
Yes.
Is that right?
Yes. If they acquire the property for a public project, and that's kind of the key. They want to acquire it just because they want some vacant land for something in the future, that may be a different story. But if it's a public project, this project was a public drainage project and it was built.
And what, and let's say we had a public spirited citizen who said, I want to just donate my land to the city of Topeka. And there's a tenant on the land. Does that tenant get relocation benefits?
I don't know the answer to that. I would assume so. It's an acquisition.
That's my
Whether it's
question.
by, let me back up and take, I don't know the answer to
Could you
this
clarify
this
something?
response.
Could you clarify, so you just said if it's for some future project, that may be a different story. I didn't understand
Well-
your answer to Justice Biles' questions, that would be a different story. It's any time a condemning authority acquires land through negotiation,
Right.
there's relocation expenses. So is there a difference if it's for a future project? I thought you said that might be a different story.
Well-
And if it is, why?
Okay, I thought Justice Biles was saying, wouldn't the city be able to just acquire it because they wanted to hold it for some future project? It's not necessarily a public project. I don't know that cities do that. I don't think they do, but I guess if they did that, it might be different. I don't know the answer to that either. But I do know the federal act, this law was intended to bring Kansas within line with the federal act in cases where federal funds were not involved. You take the case of the Kansas Highway Department, KDOT has a standing resolution that in all cases they will comply with the federal act. So therefore, anytime KDOT does a project, the federal act applies based upon a resolution they've adopted. So
How far in advance would a landowner have to terminate a tenancy before the tenants would not participate in the transaction?
well, I don't know that there's a time frame.
Do the tenants have to establish that but for the negotiations, they would not have been terminated?
Well, if they're there when the negotiations start, I think they're going to be under the act. And this act was designed to take care of tenants as well as property owners. It was designed to fill a gap that was left out by the federal act because the federal act doesn't apply to Kansas unless Kansas agencies intend to come under the act, like Kansas Department of Transportation. I've used all my time, and I'll reserve the balance for rebuttal if there are no more questions.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
If it please the court, I'm Shelley Starr. I represent the city of Topeka in this matter. I think everything that's been said so far pretty much sums up what the issues are. This isn't a complicated fact case. It's not a complicated law case, except that there isn't much case law existing on this. And since this issue is, or this appeal is based on one issue of the case, my remarks are going to be pretty brief, really, unless you have a lot of questions for me.
Let me start with one. What
Sure.
would be an example of a condemning authority wanting to acquire property through negotiation under circumstances where it would not be willing to condemn?
There's actually quite a few of those that come up. A lot of times it is for a future possibility, and those may or may not pan out. I think that there was a recent situation, and I don't get involved in that part of it, so I'm not real familiar with the facts, but where some property was being marketed, I believe, and the city thought that might be a good place to expand something that they had, but they didn't really have a need for it currently. They started negotiations on that, and then they determined that that the governing body didn't support that, so they quit the negotiations. But it's just an opportunity. It was an opportunity that they saw, that they thought they might get a good price for property that they might need in the future. But
Wouldn't it be possible for, I think you hear about school districts that acquire ground in anticipation of some future enrollment growth where a school might be needed in an area, and so it undertakes to acquire that property through negotiation. Can you think of any others?
not really, not off the top of my head.
Let me get you to what I'm fussing about on this case, which is the Court of Appeals seemingly to indicate that you'd have to have a threat or the initiation of condemnation proceedings in order for someone seeking relocation benefits to prove their entitlement. That seems to be awfully narrow. There aren't always situations where a condemning authority is going to, certainly it would be evidence if they did threaten to use condemnation authority in the course of the negotiation, but it can always be just looming out there, and you sort of know, you might be able to prove it's a reality through some other mechanism, couldn't you? Or through some other evidence besides a threat.
Well, under 26201, cities, in order to exercise their condemnation authority, they have to do a resolution and then follow up with an ordinance. So at that point in time, it's very public, and it's voted on by the governing body and all of that.
But it seems like the statute covers that when it sets up the two circumstances. One's a negotiation in advance of condemnation. The other is when it acquires through condemnation. And because a resolution deciding you're going to use condemning authority is the threshold act of initiating condemnation, it seems to me that that's covered under the second tier of this statute, that it's through a condemnation action. Would I be wrong in looking at this statute that way?
Well, I think it's broader than that, because I think when there's a public project that they want to accomplish, I think that they determine at that point whether it's something that they want to condemn property over as well. And I'm not.
You didn't in this case. You pushed out your resolution and you specifically left off the part about using condemnation authority.
Because when they looked at this, there were alternatives to acquiring the property. The study that was done showed that we could accomplish the drainage goals through, there were several alternatives, and a couple of them did not involve acquiring the property. So,
why aren't those alternatives jury questions to be resolved as to whether your acquisition of this property was through negotiation in advance of condemnation?
whether because it's a decision that the governing body hasn't made yet. So there was no indication ever by staff or by the governing body. There was no move towards condemnation.
There was no move, but there might be evidence of an intent to move. And wouldn't that come under then the first part of this statute, acquiring in advance of condemnation?
I don't. See,
Why
I don't know
why
what-
isn't this statute setting up in this first, what I'm calling this first step, why isn't the statute simply acknowledging that it might be possible for a condemning authority to not actually take any steps toward condemnation, because that's the second part of it, but through the first part, they might acquire property under a threat of negotiation, and that would trigger the entitlement to the benefits.
Well, it kind of goes to the second portion of this issue, and that is who has the burden of proving. And I think that's part of Mr. Hamilton's argument as well.
But that's two steps down. I'm just talking about the statute recognizing this possible circumstance that a condemning authority wouldn't take any steps toward condemnation, but would be, we're going to get that ground one way or the other, guy. Now, take it or leave it. When they hand them a check, and then the people that are being displaced want their relocation benefits. It seems like when you just read this, it seems like the statute is allowing for that factual circumstance. Now, it may be that somebody's got to go prove it and how that burden of proof, but that's 2 or 3 steps away from just interpreting the statute, which is what we're, right?
Yes, I guess the part that is difficult is at what point in the process does the city have to reveal that it would intend to condemn property if it can't acquire it voluntarily?
But isn't that why we have juries? To resolve those kinds of factual disputes where you say, we did not have a black heart when we wanted to negotiate here, we just wanted some ground. And they say, no. You've got these emails that say, well, we could condemn. I mean, regardless of the credibility of or what's ever being said here, why isn't that a jury question?
It makes the process burdensome, that's for sure, with regard to, I guess if the condemning authority knows in advance that this is going to be a problem every time, then maybe they'd come up front and say, under no circumstances will we condemn this property.
Or are there instances like that? That's my question. The city has a desire to have a piece of property for a certain purpose, but they want to acquire it through negotiations, but in no circumstances will they acquire that property through condemnation. Does that happen?
I think
does that happen where you'll do this project, but you won't do it if you have to condemn, but if you can get it through negotiation, you will?
Yes, because not everything is. No project. A lot of the projects that we do may not need to be done now, or they could be done in alternative ways, and so I think there are a number of cases where that would be the case. This is one of those.
Can you give me a concrete example of how we give meaning to that phrase? I mean,
In advance
in
of
advance
condemnation.
of condemnation action.
I think there has to be some overt indication by the governing body that they would condemn the property. That is how I understand it.
And would an overt act be at least 2 representatives of the city of Topeka indicating to the landowners that if negotiation failed, the city would then have to condemn the properties?
Actually, I think it would be on the governing body to make some sort of overact, because the staff can't bind the governing body.
So you're saying that the staff members negotiating on behalf of the city are not authorized to threaten condemnation, even though they do so in the course of negotiations?
If they do threaten condemnation, that doesn't bind the governing body to condemn.
But why
Let me-
doesn't the first part of this statute simply create an evidentiary question as to whether there's a likelihood that condemnation will occur if negotiations fail?
Because the city can't condemn property without taking some action by the governing
But
body.
then you're in the second part of the statute
I don't-
that says
I
through a
disagree.
condemnation. I mean, when they take a step, they are moving forward with condemnation. They have to take that step in order to exercise that authority. This first part of the statute, as I'm calling it, seems to be talking about something else. And I think this something else could be the situation of these particular plaintiffs.
I believe that if the statute meant for the cities to pay relocation expenses every time, it should have said that.
But we're not saying that. We're saying there's this middle category. And it may only occur a few times, but it is this factual circumstance that would have to be proved where those relocation benefits would go to a displaced person.
So if a condemnation can only be authorized by the governing body, at least in the municipal court or municipal area, and a staff member threatens condemnation and the governing body decides not to condemn, does that qualify?
Counsel, let me approach it maybe a different way. Isn't the legal question whether or not, but for the successful negotiations, the property would have been condemned? Isn't that the legal question that the statute sets up? And then maybe it is, maybe it isn't, but then you get into debates about how you prove up the legal standard, the evidentiary questions. But it seems to me we have to know what question we're asking. And isn't that the question? But for successful negotiation, this property would have been condemned. Why isn't that the legal question?
How do you prove that?
Well, I don't want to get to the how do you prove it question. I want to know what the question is first that we're trying to resolve.
I don't know. I don't know the answer to your question, but I will, since you're posing alternatives, I would pose an alternative that what if the situation is the seller is very anxious to sell their property. Maybe they have back taxes that they owe or something along those lines that they don't really want to reveal, and they're very anxious to sell the property. This kind of, and the city says, well, if we have to pay relocation expenses, we don't want to buy it. So you're kind of putting a chokehold on negotiations to some extent by requiring a city to pay relocation expenses anytime there's, I guess.
In this circumstance, the city told the landowner to displace the tenants because the city did not want to pay. Or, no, I'm not, it was the deputy city attorney. And maybe your legal representative is not authorized to speak legally on behalf of the city commission or city council, but you did have a representative specifically say that.
With
And-
regard to a different tenant, but because that other tenant had already agreed to move, but until they were gone, we didn't want to have to do something to kick them out if they stayed against the lease.
Counsel, I'd like to see if I can pinpoint, in your view, where you think this obligation kicks in. The statute talks about acquiring through a condemnation action, so let's make that up at the far end of our continuum, and that is, an action has been filed, the land has been condemned, and the action, everything is over. On the other end of that continuum is how I understood opposing counsel to say things stand, and that is, it's almost strict liability on the part of the governing body. Any acquisition of land for public purpose by our government must pay relocation money. And I think he was saying at the end, it even includes gifting by a landowner. So assuming those are the two ends of the continuum, where do you think the city's obligation starts to pay relocation benefits?
When there is some official action by the city authorizing condemnation or the possibility of condemnation of a property.
And that would be by the governing body of the city, such as passing a resolution? Is that the triggering event?
I would say so.
And anything that is before that, in advance of the condemnation action, does not qualify.
Correct.
All right. You're out of time. Do you need a few seconds to wrap up? Do you think you've made your points?
No, I think we've covered everything I intended to cover. Thank
Do
you.
we have any more questions? Thank you, counsel.
May it please the court. Ms. Starr, I think if I understand what she's saying is that unless the city passes a resolution and an ordinance to condemn, they shouldn't have to pay relocation benefits.
Well, I think she said the triggering event was the resolution.
Okay, resolution then. And it takes both to do it, but the resolution. But of course, that's never done until negotiations fail. I mean, a landowner never be able to prove it if that happened to be the case. Because they never file for a resolution, has to be followed by an ordinance, but even a resolution unless all negotiations fail and they're moving forward. And you know, the burden of proof issue, if it is a factual question, and I contend it's not, but if it is, shouldn't the burden of proof be on the city to prove that they wouldn't have condemned it? They would have abandoned the project rather than condemn it. Now, the Court of Appeals inserted an intent into the statute, which was not part of the statute, in my opinion, that you have to show that the city intended to condemn. I think in this case, we could show that. But this is a case of first impression on the statute. I mean, there are cases where the cost of relocation would be greater than the value of the land. For instance, an Office Depot is an example. You try to move an Office Depot store or a business like a dry cleaners. You know, they have all these chemical machines and things, and OSHA won't let them be moved if they're used so long. You have to put in all new ones when you relocate. I mean, those are all things covered under the Federal Act. And in this case, that's not the case. I think the kind of the agreed amount is something under $20,000 apiece for both these tenants, for each tenant. So I don't think there should be an intent. I think if there is a burden of proof, if you place that on someone, it should be on the city to show that to prove that they would have abandoned the project rather than going forward with it.
There's no, refresh my memory
Sure.
on this. I should know this, but I refresh my memory. There's no provision for attorney's fees when a displaced person prevails. At least unless it would be in the context of an actual condemnation. Is that right? Or am I
There is
missing-
no, you're absolutely correct, Mr. Spiles.
How do
There's
we,
no provision in this act for the tenant if he has to bring an action and prevails.
Counsel.
There is under the federal act, if you, on an inverse condemnation, doesn't apply in Kansas, but there is under the federal act, and you prevail.
how do we decide the burden of proof question?
I'm sorry, Your Honor.
How should we decide, what do we look to decide who has the burden of proof?
Well, I think probably for my first argument would be there should not be a burden of proof. But the second one is if there is. The only way I know, Judge, it's not imposed by the statute. I think the court would have to impose that.
I mean, typically a party, the burden of proof is on the party bringing an action.
That's correct.
And so you're asking us to put the burden of proof on the defendant in this case.
If there is a burden of proof.
If there
yes.
is, and I'm just asking, how do we get there? Other than, I mean,
Well,
do we just do it because that's the right thing to do from your perspective?
I guess that's pretty close to it, yes.
Any more questions? You have any further presentation, counsel?
I don't think so, Your Honor. Thank you very much.
All right,
For
thank
no
you.
further questions.
I thank both of you for your arguments this morning. Court will take this matter under advisement.
Thank you.